echacha obi biara sabre ensem de ebi wo fie ha ensem no yemunra ensem no emu
appear could be our leading counsel for Chairman Bernard and Chibosia Kon Chama Wontumi Eko Kopiemu Ewo Asempe FM. And the only obi etwetwe nkomo bebre na efa Chama Wontumi court cases no. Na the main talking point no eko ye Chama Wontumi case a ewo criminal court for the summer boy case a court no ahyese na me adoma 3 July ebe and then the final ruling and as a judgment eba betudwa eno ana obi ekobisa lawyer and appear could be say na me adom na 3 July do court na court no convict a sentence in the client Chama Wontumi a ebe surprise no and answer and surprise no na lawyer and appear could be HM says ye had 2 charges ye dey board Chama Wontumi and the client any account mining one assignment without permission from the minister. Now 2 facilitating the permission the provision of mining support service without ministerial permission. You have 2 charges here. You the board and the client Chama Wontumi any account mining now. During court proceedings no or not Chama Wontumi lawyers lawyer and the appeal could be filing motion or court say assignment bia Chama Wontumi any account mining edema Henry Okun na aban ni se o testify against Chama Wontumi nenwe Chama Wontumi afias no assignment bia Chama Wontumi any account mining ma Henry Okun no omo copy as part of disclosures. There's nothing like that. Omo anya copy bia ma Chama Wontumi lawyer say Chama Wontumi any account mining assignment be say Emma Henry Okun na aban ne say o testify against Chama Wontumi no. Na lawyer ND appeal could be SHM say o respond to court and say under land law new land act 2020 for assignment to be valid it must be documented and authenticated and endorsed by signatures. Na Henry Okun abra obaye testify against Chama Wontumi court no obechem say Chama Wontumi na no keke appointed no as general manager for account mining. Na Chama Wontumi amfa nensa secret so and sign bibia say ono Henry Okun no Chama Wontumi no as general manager for account mining. Na the breaking news case we say Chama Wontumi lawyer ND appeal could be filing an application to withdraw from the case of the Republic versus Wontumi and others. The summer boy case court no assess me aduma 3 July and then the final judgment and as in ruling no ebeba no. Yanje bre yenkotie nsem wenyina emra.
Would you be surprised say judge no client or convict or client sentence na we are still leading into temptation but the charges were assignment without authorization from the minister, yes, and facilitating the provision of mining support service without ministerial permission. We need 2 charges against Wontumi, against Olivia, on Summer Break, and we filed a motion in court. So assignment be Chama Wontumi na account mining. I am Henry Okun. We copy as part of disclosures. There's nothing like that. Okay. And response to the court to say under land law, new land act 2020. Yes. Say for assignment to be valid, it must be documented and authenticated and endorsed by signatures. Sure. If there is nothing like that, if the law says there's no assignment, a procedure, it has to be a valid assignment, and it is not provided. And also, my assignment, I see a memo say, to name me and the chess Otumika. You also to me, that's what I said to me. Boy, if you are making baby, boy, yes, meeting baby to my goodness. Now I charge me, say, I pay Otumika. Now, Mr. Mika, if you hear the call, we said that you go baby, I was Otumika. Is this law? This is the situation we are.
Based on the two charges, no?
And we see many support services provide money. They provide money. Yes, sir.
Yes.
Chairman to me, any compromise. There is no evidence to suggest that mining. And to support services, if it was even so provided, who did not provide it to? Support services and provided in the vacuum.
Yeah.
And to say what to baby, there's a mean and minimum. And then we say, Bella, go officially, and say, make a problem. So,
yes.
But me, Bay, and the mayor under the law say, we could pray, be officially, or more quiet. Nasa wa manu kan kura nasa nyama kopra. Why would you charge me? The house owner.
Yeah.
So many support services it must be delivered to a miner.
And you made all these arguments in court.
And it was in fact, it was said that Chairman to me a letter called Regional Security Council say illegal miners and massacres so a good year. And there is record say
to show
Regional Security Council for number from watching even in evidence here chief sign for Bikra where are they? And also crown Regional Minister then by the dear dancer Obaho about the chief of be and which was said assassin would be going to have illegal miners at 2 minutes are dangerous. When you talk of how do club it to do. Anything Ghana for as policy. You say you encourage community say baby and who send for acquire illegal money and not 2 minutes and I do it to the Asmabano. Community no community support. And then you send me a new and my World Bank for Mexico. Say, young first away and quiet land reclamation for illegally made portions of the new land. I said, me and my mommy, the concession, someone could try a good day or become a dancer. Let me call and confer to 200 million horse and let me call me, my wife could tell me. Let me as a minor, a man concession holder, me shall see. And then say, how do I then you go for me? You talk about me. Let me see any senior boy. We come and bring in. Let me walk to arrest the place and also my body.
Wow. I mean, it's good, sir. Will be charges. And
I make a say, can move your work to home. Naka, say, you're for the most one baby. No more baby. Now, some way I clean. Politics about judicial system and yet 1 and yet 2 and yet 3 and Ghana for a constitution under a sanctuary. The sanctuary judicial system, yes. So be big, or be 2, or be young, I had the baby again court. There's a court when you say, so we cannot sit and allow our sanctuary to be populated by the devils that chase us. Thank you.
Now, that's in the Monday, general jurisdiction and
criminal court.
Criminal court 4. Okay.
Yes.
Now, Monday, I'll be there. I will show argument, in support of the withdrawal application. We'll do that. Now, way on social media dated 11th June 2026. 06 should be June 2026, which is today, found on 9:08 a.m. in the Superior Court of Judicature in the High Court of Justice, Accra, AD 2026, docket number the Republic versus Bernard Entribo Siako at Wontumi, first accused person, Thomas Entribo Siako at large, second accused person, Wontumi Farms Limited, third accused person. Notification of commencement of plea negotiation, section 162 C3 of Act 30. We hereby notify the Honorable Court that the first accused person herein has, through his counsel, Mr. Andy Apiakubi Esquire, in a letter dated June 5th, 2026, to the Honorable Attorney General, made a request to initiate a plea negotiation in respect of the charges in this trial. Dated at the Office of the Attorney General, the Law House, Liberia Road, 11th day of June 2026, where Nipa was signing Dr. Justice TRENZ, the Honorable Deputy Attorney General, to the Registrar High Court General Jurisdiction, Accra, and for the service of the above named accused persons or their lawyers. Counsel, we are aware of letterway.
Me and the written. Okay, my Attorney General, in line with the law. Okay. Justice Sims I will go to the appropriate provision. Yes. In which I make sure that okay. Now, indeed, if I read that provision I rely on, I say it comes under plea negotiation.
And a plea negotiation. This is in Act 30.
Not in Act 30. Okay. The problem that we have in the country is existing laws now, provided enough education. And today, you need that existing laws. Yes. And then you can quote a bit by any nation. Repeat laws. And then cited. Current law. Yes. I to change. When they say a plea bargain act, sure. It comes as Act 1079. 1079. Yeah. And then is on plea bargain, sure. Until Section 162 of the previous Act. And the one amended 162. Okay. And you capture as 162A. And the plea negotiations. Yes. Now, Samuel came into effect on 22nd July 2022. 2022, yes, that's true. 2022 July, no, this is the yes, provision. But also there is Section 35 of the Court Act. And also provisions of plea bargaining. And it is not plea bargaining act. We have Section 162A. Yes. 1B. If you can't permission, let me read this. Subject to subsection 162, subject to section 162B, a person charged with a criminal offense may at any time before judgment, negotiate with the Attorney General for a plea agreement. Now, a plea agreement, if I go to 162A1B, to withdraw the charges against the accused person. And one of the expectations of the negotiation, the plea negotiation, right? Now, so we call a social. I say, 2A, 2C. Yes. I see. No, A. Okay. 2A. Okay. The prosecutor shall, before the commencement of the plea negotiation, inform the accused person of the right of the accused person to be presumed innocent until proven guilty. So there's no way I say would be apply for plea negotiation. Yes. And guilty, and now admit guilty. No, that's how the law is. You will stay on the same presumption of innocent until we are proven guilty. Now we call it plea and say negotiation should result in a withdrawal of the charges. Yes. So where is the admission of guilt? Yeah, is it not because who said the Section 35 now become under the Court Act? That section has not been repealed. It is still a section in force. Yes. That section also speaks about plea bargain. Yes. And until plea bargain itself, not right, we rely on. Right. And because it's still in our statute, let me also come to interpretation. Sure. By way of conflict of laws. Yes. And you agree with me in conflict of laws. Yes. The letter presides over the former. Sure. And I'm going to be specific. Thank you. Yes. And your general application. By inference, that law 35. Yes. It's retired. By Section 35, it's retired by this immediate one. By way of hierarchy of norms. Yeah. Until you know he is provided education
and I think Nipa Bebruna, because when you read section 35 now, that is probably what has created the confusion.
And the first one, any opportunity of studying the conflict of laws because as an elective faculty.
Yes.
And it's very fortunate. So we advise you to select that. Then we are called into interpretation. Now we struggle.
Yeah, but Udru Makola you'll be taught.
But the basis starts from the faculty. It's Makola is interpretation. The basis is conflict of laws. You need to carry your knowledge in conflict of laws into interpretation in Makola. And yes, Makola will be hanging. So you come to
so much to the point he said prosecution when he said charge as co-conspirator for causing financial loss to the state. That is the level of knowledge, in-depth knowledge of whatever the kind of transactions that Mr. Kwabena now on the outside observer or originally not standing in the dock with the accused couple. And state necessarily kind decided on maybe a tactical decision to drop all charges. Normal transforming from a defendant or protected on one liberty to a prosecution's ultimate insider. Now, possessing intimate first-hand understanding of the relationship between the accused or private companies and at the bank. Now the testimony that trading here or what's our tripartite relationship between companies causing financial loss to the state charges we co-accused and banking relationships. Now the engine of all financial movement, because it can't be free National Signals Bureau accord these special purpose vehicles. Now Mr. Kwabena Kasa and copy more banko. Now or any true Madam Donko. So that is the key immense nature of the testimony. Bank statement they better match how transactions they move here. But nipa odi any kind entity checks a true amount a call tell a ho a kaka nsem. The engine of these financial transactions Madam Mildred Donko, because in some kind and say Mr. Kwabena transaction be about bank in the more or treating her as agent because no classified as a particular client or treat as prestige account. Now this is the nature of the testimony. One, prosecution for no depend say a near man no or your man Mr. Kwabena or person professor one a highly irregular setup. Na enye normal say a banker ebe holding